Judge, the state does oppose bond in this case. Criminal bonds would be to no.
Right out of the gate, notice what's happening here. The state isn't just opposing bond emotionally. They're laying out a methodical legal roadmap. Judges care about patterns, timelines, and consistency, and that protocol language tells us this prosecutor is signaling. Nothing about this case is new or surprising.
Follow a particular protocol when I go through my bonds. I always start with the case history. I'm talking about an incident date of February 20th of 2025. It's less than 12 months ago. An arrest date on this case was July 8th, 2025. This case went before the grand jury August 19th of 2025. We had a bond hearing on August 19th of 2025 as well, which we're going to talk about in a minute. The trial court date on this case is set for August 3rd of this year, which is less than 1 calendar year from indictment. That is incredibly fast.
This part is critical. When the state says a trial date is set less than a year from indictment, they're cutting off one of the defense's strongest bond arguments: delay. In bond hearings, speed works against the defendant. The faster the case moves, the weaker the claim that continued detention is unfair.
Opposing counsel did mention the additional time based on the continuance that, for all intents and purposes, had to be granted. That is not a consideration for the court. The court's structure in regards to this is pretty straightforward. There is no material change in the circumstances of the defendant. That's where we are. I'm going to read from that bond order on August 19th, 2025. After hearing evidence presented regarding the defendant's motion for bond, this court finds the defendant is a risk to flee the jurisdiction, not appear for future court appearances. The defendant is a risk to influence witnesses. The defendant is a threat to the community and family members, as testified to at the defendant's hearing regarding bond. Through all of the testimony and argument we have heard today, there has been nothing to dispute that fact. Anything, I think it could be argued that the flight risk is actually more significant now than it was.
Listen carefully to that line. The flight risk is actually more significant now. That's not rhetoric. That's strategy. As evidence stacks up and consequences become real, courts often view defendants as more likely to flee, not less. This flips the defense narrative completely.
4. The family in this case does oppose bond judgment. Another thing that I want to address is at the beginning of opposing counsel's argument, our relationship with both sides is as much as we can make it. Miss Bruce, Mr. Nolan, and DJ, the biological father of the defendant, they have been invited to our office constantly. Anytime we have spoken to the Brock side, we have reached out to the other side as well. They choose not to come. I sat down on that August 19th, 2025. We sat up in our brand new grand jury room up on the 5th floor, and I sat and answered their questions for at least a couple hours. I think it was about 2 hours that we were up there. They have been asked to come in every single time. I am inviting them to come into our office to talk to me today, tomorrow, any day, anytime. I cannot make this more clear. Anytime they want to come in and talk about the case, I am available to them. If they want to, we can set up a conference call on a weekend. If they need me to drive up to Marietta or up to Rome, I will drive up to Marietta or I will drive up to Rome. I drove up to Marietta a couple weeks ago with my investigator. Bruce was actually not there. So we have tried our very best to have a good relationship. They have turned their back because they do not believe that we are prosecuting the right person for this case.
This is where things get emotionally charged. The prosecution is defending its integrity, almost preemptively. When a family believes the wrong person is being charged, that tension can spill into the courtroom. And here, the state is making sure the judge knows access was offered, transparency was claimed, and refusal was voluntary.
That was something I told them from the very beginning. I'm going to be as open and inviting as I can be, but we are not going to agree on that fact. They choose not to come in. I have conversations on the phone with Mr. and with Ms. Bruce because they live far away and it was difficult for them to come in. Any person in that family who wants to come in and talk to us can do so. At that meeting on August 19th, I told them to bring as many people as they want to. Friends, family, whoever they like. I invited them to record the interaction if they would like to. I have no problem with it. The state is not scared of talking to the family on either side. We invite them. Going back to the Brock side of the family, Judge, I do have a statement from them. They opposed bond as well for the same reasons that they opposed bond in the first time. I would like to read this statement from them if I could. The seriousness of the charges before this court cannot be overstated. The accused is being held and charged with malice murder of 2 people. These were intentional violent acts that were permanently destroying our family. Granting bond in a case of this magnitude would undermine the gravity of these crimes and the devastating harm that she has already inflicted. Then they move to addressing the Ayala factors. We remain deeply concerned about flight risk. The defendant is facing the possibility of life-altering consequences if convicted. Given the severity of the charges, the incentive to flee is substantial. The immediate family has the resources which would enable her to flee. Her family maintains that she is innocent, and given her manipulative behavior, it is possible for her to flee. Once released, there would be no meaningful way to ensure the defendant remains within the jurisdiction or appears for future court proceedings, since family and close friends have homes outside the state of Georgia. We are also gravely concerned about witness intimidation. This case relies on witnesses who must be able to cooperate freely and safely with law enforcement and with the court. Releasing the defendant creates a real and reasonable fear that witnesses could be intimidated, influenced, or discouraged from coming forward. Even indirect contact or perceived threats would be irreparably damaging to the case. Finally, and most urgently, we fear for our own safety.
This section hits the heart of bond law. Safety, intimidation, and fear. Judges don't just weigh evidence. They weigh risk. And when families articulate fear this clearly, especially in a double malice murder case, courts tend to err on the side of protection rather than possibility.
The loss that our family has suffered has traumatized us and left us vulnerable. The thought of the person accused of killing them being released into the community causes us constant anxiety and fear. Bond would not only endanger witnesses, but also place our family under continued emotional distress and fear for our physical safety. The accused is being charged with 2 malice murder counts. These are horrific and violent crimes of which she's being accused. The defendant's second bond request. This is the defendant's second bond request, and nothing has changed that would justify reconsideration. The risks remain the same, if not greater, as the case moves forward and the consequences become more real. Our family would not be able to sleep in peace knowing that she is not in protective custody. Judge, it's the state's position that on August 19th, 2025, she was a poor candidate for bond. And as I stand here before you today, she remains a poor candidate for bond, and bond should be denied as such.
And this is the closing hammer. Second bond request. No material change. Escalating risk. In plain terms, the court already said no. And today, the state is arguing the reasons to say no have only grown stronger. Let me ask you, should bond ever be reconsidered when the stakes are this high? Drop your thoughts below.
So that was crafted by Kim Bowling on behalf of the Rock family. Kim Bowling. It is. We did. We had sons. We had sons and her and then a friend of the family. All correct. Going back. I think so, Judge.
That's right.
He was not the thing.
Correct. There's significant numbers on the side.
They lived together.
Not in recent memory, Judge. Not in recent history, is my understanding.
Anything else to say?
Nothing else from the state, Judge.